most active and most impressive scholars at the EU level. And it's a great pleasure to share this with her. We will try to address a quite difficult issue because for those who are not aware of that, the EU laws regarding data protection and data sharing and so on are changing dramatically in these years. So we have a huge amounts of regulations that are somehow in the process of being approved. We still don't know what's going to happen with them, and it's going to be quite difficult to provide you with a fully comprehensive framework. So I will try just to make a presentation focusing on the most important things that you should keep in mind in order to understand it all. So as I will leave room enough to Vera Lúcia to add whatever she considers interesting and important. And then there could be some time for your questions or whatever, and we will be glad to answer them. Okay, so I will just be sharing my presentation right now that I think could be helpful to you. So I hope that now it's sharing, and you could more or less see my presentation. Yeah, I guess you can. So I will start with the some very basic ideas and some type of previous advices that might serve you well. The EU is really looking forward to building a kind of a common market of data, to be sincere, in order to make it possible to share data in so many different ways. Just to give you an example, this is more or less what the EU has got in mind and what they are committed to do. They want to increase the data flow at the EU level by 2025, and they are looking forward to increasing it dramatically. If you take a look to those data, you could see that the forecasting increase of the global data volume is really impressive, and they want to really increase also the percent of EU population with the skills and the number of data professionals. This will obviously be extremely difficult. We are just considering a framework that's, that has to do or a time lapse that only extends to like 3-4 years from now on. So they will need to go fast, and this is precisely what they are trying to do. Main problem is that, in my opinion, we have already wasted a lot of time. Okay, so we are somehow on delay regarding to some other spaces. So just to make you an idea of what we have right now, well, the EU regulation about data, most probably, or the history should start by mentioning the directive of 2011 that was related to cross-border healthcare, meaning that the EU at that time created a kind of directive. For those who are not familiar with that, a directive is a kind of soft regulatory tool in which the Commission tells the member states what they are supposed to do, and they have to more or less introduce some changes in their own internal laws just to go on in the way that the directive tells them to go. But they are quite free to do that. Instead, the regulation at the EU level means that this is a new law applicable in all the EU landscape. So it is directly applicable, and it becomes law, internal law in all member states. What they produced in 2011 was a directive. And it was a directive that was intended to try to help all member states to create somehow a common structure regarding data sharing in terms of health data and so on. And so they more or less provide them with some guidelines on what they were supposed to do, and what they should do, for example, to be able to share electronic health data, or to have some interoperable records and so on. This was in 2011, as I'm telling you. Main problem is that at the present moment, I dare say that somehow this kind of a directive was not really so successful. Indeed, the analysis that we have made afterwards states that its effectiveness and efficiency has been rather limited due to the voluntary nature of the e-health network actions. There was a kind of a platform, My Health EU, that was created in order to help member states make their records and their health data interoperable, but it did not work so well, and only was implemented in 10 member states, and only there are 2 services that are really working well in between these 2 services. There are some countries, that have arrived into this kind of agreement, such as, for example, Finland and Estonia, but there are exceptions to the general rule. So there are also some malfunctions that really hinder all this effort. For example, most of the EU countries do not really provide patients with a kind of a copy of their electronic records. So that's not been implemented and so on. So there are not really this kind of a electronic record somehow. So this is more or less what we have right now, or what we had after this directive. In the aftermath of that, in 2026, the EU created a new tool that is very famous and popular, that is called the General Data Protection Regulation. And this was really a regulation, so it is directly applicable. And this was meant to protect natural persons with regard to the processing of personal data, but also to ensure the free movement of personal data at the EU level. So it got both these objectives, even usually we forget the second one. There are some key concepts in this GDPR. One is the concept of principles. Then we have legal basis for data processing. We got the idea of data subject rights and the idea of safeguards. I will try to explain you more or less the most important of them all, in my opinion. That is the idea of legal basis or legal grounds for data processing. The idea is that, in principle, you cannot process data, or at least you cannot process them if you don't have a nice legal basis. What could be this legal basis? Well, the GDPR provides 6 different options. One is consent, the other is the performance of a contract, then you get legal obligation, then vital interest, then public interest, and finally legitimate interest. So whoever is willing to process data has to make sure that one of these legal bases, legal grounds, applies. It might be more than one, but at least you should have one of those. But there are some special categories of personal data that require something else. Indeed, the GDPR vetoes this kind of processing of special categories of personal data, and this includes genetic data and health data. This ban, indeed, can only be avoided if some concrete circumstances apply. So the circumstances that could make it possible processing this kind of data, special categories, are more or less 10. One is explicit consent that you get related to employment and social security, vital interest, legitimate activities with with corporate safeguards, that if those data have been made public, the legal crimes or something like that, etc. So it's like more or less like 10 of that you could be able to consult. Indeed, a main problem that happens with this is that if you could not really find any of these, health data cannot be processed at all. So you have a kind of 2 steps in the case of this particular data. First, you need to find one of these 10 circumstances that makes it possible to avoid the general veto of processing of data of special categories. And once you have been able to do so, you have, if you are the responsible for the processing, find a kind of a legal basis, one of the 6 that I have described before, to make sure that you can really process those data in a legal way. It is true, however, that somehow the GDPR included a kind of clause that made it a little bit, or should have made a little bit easier the processing of personal data for research purposes. This is what's been included in Article 5.b. For those who are not aware of that, in general, personal data can only be processed for the purposes that are covered by a legal basis. So, for example, if you collect data in order to provide a kind of a healthcare, you can only use those data for this kind of healthcare data processing, healthcare-related data processing. You cannot use them for any other purpose, unless you consider that this secondary use is compatible with the first one. In this case, you could use them. The GDPR in general provides a kind of test just to check whether this use is compatible or not with the preliminary, with the first use. But in the case of research, there is this clause that states that in general, a secondary use that has to do with processing for scientific purposes will not be considered incompatible with the initial purposes. So, in theory, you could perfectly use those data that you have, for example, collected for healthcare purposes in order to perform some kind of a research. This, in theory, is possible. It is true that there's an Article 89, that included some kind of safeguards that must be respected if you are doing so. Mostly that you have to introduce pseudonymization, for example, and you have also introduced some separations in the technical team and the research team. You have to introduce some kind of a guarantees from an organizational way of thinking and so on. But I mean, in theory, you could do so. And moreover, member states could provide some derogation from the right of the data subjects, namely, the right to opposition, the right to delete data, and so on, if they consider that this could be useful. However, there is a main issue regarding this general system and what the GDPR had in mind. The idea was that first of all, whenever you want to avoid the veto, you need something that is quite special. In most of the circumstances, you need to have a member state regulation. I'm coming back for a moment, but if you read it, for example, imagine that you want to process some data for archiving purposes in the public interest. As you could see in the second part of this clause, it always says that you should do this in accordance with Article 89 based on union or member state law. So whenever you want to use this kind of clause, you need to apply for union or member state law. This is the first thing that you have. This happens with lots of these clauses. Indeed, there are some exceptions, such as, for example, consent, when you don't need that. The idea of consent has been developed in union or national law. But otherwise, you will always need that a concrete member state has passed a law that allows you to avoid this veto. So main problem is that some member states never develop this kind of a law. So some of the exceptions to the veto really do not apply in some member states. In practice, this means that most of the researchers still need to use consent as the data, as the legal basis for data processing. And there's also another issue, that is that Article 9.4 of the GDPR stated that member states may maintain or introduce further conditions, including limitations with regard to the processing of genetic data, biometric data, or data concerning health. So in practice, this all meant that member states make the final decision on whether or what are the real conditions that apply if you want to use health data for research purposes. So this is what happens in practice at the EU level. So we have a quite fragmented framework with member states showing great differences in between them, and this is really not working well. So some of them, for example, require for consent if you want to use data for research purposes. Some others introduce as a kind of requirement of the participation of an ethics committee in all that. And some others just let more or less the use of those data for research purposes, if there's a secondary purpose, just with some safeguards, such as, for example, pseudonymization, but they don't require nothing else. But in practice, this is what is happening. That's quite fragmented. So the point, and now where we are, we find that the Commission is really looking forward to full this kind of data sharing, and they really want to create what it's called the European Health Data Space, meaning that they want to promote health data exchange and support research on new preventive strategies, treatments, and so on. So the idea is that the Commission approved a kind of communication explaining the European strategy for data. That is what they really want to do right now. And the strategy for data is based on some simple ideas, but that I think that they're very functional. They want data flow. They want to the data can flow the EU and across different sectors. They want to have the availability of high quality data to create and innovate. They want to somehow ensure that the European rules and values are fully respected, and they want to have all those rules clear. So in practice, what they really want to have is create a real space of data sharing all over Europe, I mean, across the EU countries, and they want to prove that this could be done by following some strict rules regarding data protection. They want to create 9 data spaces as a whole. So it's health, industrial, agriculture, and so on. But the first data space that they are creating is precisely that related to health. So that will be somehow a kind of pilot. Why they are sharing health, in my honest opinion, is just because it's pretty easy to convince citizens that health is so important and that the research related to health is essential. And so it's good to have your data somehow shared. So there should not be so much opposition, related to a health space, that if you are considering, for example, a finance, a space, or a mobility space, or anything like that. So that's more or less what they want to do. And here we come to what is new right now. Well, as I was telling you, recently, it was just, I think, May this year, it was made public that the Commission was willing to create a new regulation, on the European health data space. So it will be a kind of directly applicable law that has to do with the creation of this health data space. Why is that? Well, it is aimed at 2 different things. One is to try to help patients and natural persons indeed gain control over their personal electronic health data. And that is a kind of primary use of electronic health data. And but they also want to really support other proposals that will benefit the society as such. And this includes research, innovation, policy making, public health, and lots of different things. And that will be a kind of secondary use of electronic health data in general. So furthermore, they want to improve somehow the functioning of the internal market or internal sharing of data by laying down a uniform legal framework. So that's more or less what they got in mind, and this is the main purpose of this new proposal. Whatever we say about this proposal is right now something like a kind of ideas that might change, because it will be negotiated between the Commission, the EU Parliament, and the Council, and there will be a definite text. But there are some highlights in these proposals that seem very interesting. First of all, is that it obliges all member states to provide the tools that will serve all those data subjects to gain easy access to the data in electronic form. So this means that they will have to make sure that all data holders, and this is an expression that really doesn't, it's a little bit complex, but more or less means those who have a lot of personal data, make those data available in an electronic format. And this data should be portable for all those who will ask for that. So interoperability should be ensured, and security also will become mandatory requirements. So all those, furthermore, those who are really creating electronic health record systems will need to certify a kind of compliance with some standards that will be created to this purpose. Some of them already exist, some others will be improved, and so on. And in order to make sure that these rights are safeguarded, all member states will have to appoint some digital health authorities that will participate in this kind of a cross-border digital infrastructure that will be called My Health EU, and that will support this part. There will be also another infrastructure. I will talk about it further on, but there will be also an infrastructure that will not be related to this primary use of data and data sharing of patients, but kind of a sharing of data for research purposes. But this is more or less what they got in mind they want to create. Then there are some other very important highlights regarding what is research and innovation as such. So the idea is that in general, all researchers, innovators, public institutions, and so on will gain access to large amounts of high quality health data. It is true that under some strict conditions that they will gain this access, meaning that data holders will be obliged to share this data. Indeed, they shall make a lot of different categories of electronic data available for secondary use. Here is the list. I will not read it all, but if you take a look at that, it means that it's almost everything, because it includes, of course, electronic health records, but also includes lots of data that come from devices, from apps, from a lot of different bases or different devices and so on. So lots of sources will really produce those data, and those who are data holders will be obliged to somehow create this data, and they should be available for data sharing, so in a quite portable format and so on. Well, it is true that they will be obliged to provide them, and those data will be available, but not for each and every purpose. But the data user, meaning those that will have to or are willing to use those data for research purposes, for example, will have to provide a nice explanation on why they want this data. Article 34 really specifies which type of finalities are really allowed under this new regulation, meaning what type of finalities will let all those data users gain access to the data. There are a lot of finalities, to be sincere. Okay, I get just introduce some of them here. I've got them here. You could just take a look. There are lots of different nice finalities that are included there, but one of them, for example, is scientific research related to health or care sections, and some others, such as, for example, reasons of public interest in the area of public and occupational health. So in general, I guess that this would allow all the researchers to gain access to these databases. Okay, so that's more or less what it is really right now producing. So the idea is that in order to make this possible, there will be a kind of a mechanism that it seems quite simple. Those who are data holders will need to show some concrete bodies that will be created for this purpose, bodies that will be called health data access bodies, that they got these databases, and that will be listed and registered in that. And data users, if they are willing to gain access to those databases, they will have to make a request to the health data access body, and the data access body will tell them whether they consider that it makes sense or not. If they consider that this is the case, they will tell the data holder that there will be an access to those data in a period of 2 months' time or something like that. So that's more or less what how the system works. There are some bans regarding the use of data. Those data cannot be used for example, for decisions which are detrimental to citizens, or to design harmful products or services, or increasing an insurance premium, and so on. So Article 35 states what kind of users are not allowed. Okay, so and the access will be allowed for just the specific purposes the data user is asking for, not for any other purposes. So it would only be used for those ones. So that's more or less how it's going to work. There are some safeguards regarding this. I mean, it will not be just a question, just like saying, well, the data holder will just give the data user the data and that's all. No, it's not going to work like this. First of all, in general, those data or the data processing of those data can only take place in secure processing environments. We need to comply with very high standards of privacy and cybersecurity, and no personal data can be downloaded. This is very important because the data users will never be able to bring this data with them. They could use them, but in these secure processing environments. Moreover, in principle, all data share will never allow the data user identify the data subjects. Okay, so in general, data will be anonymized, and all those who are gaining access to those data will be gaining access to anonymized data. If the users consider that anonymized data will not serve them well for the kind of research, they will have to justify that, and they will have to convince the access body that they really need them. And in this case, they will gain access to pseudonymized data. That's more or less what we have. And in order to do so, there will be a kind of another structure that will be called Health Data EU, that will serve to support cross-border projects and so on. Okay, so there will be another agency. So as you could see, the system is not so complex. It's quite easy to understand, but the governance of the system is a little bit complicated. First of all, as I was telling you, a new health data space board will be created, composed by representatives of those regional health authorities of all member states that I was mentioning before. This kind of new body is meant more or less to introduce some interpretation of this regulation, so as everybody understands how it works. And there will also be included some members of the EDPB and the EDPS, meaning the representatives of the states in the kind of commission that has to do with the interpretation of the GDPR, the General Data Protection Regulation, and the data protection supervisor of the EU institutions. Indeed, one of the conflicting issues that's been included in this proposal is that this is somehow voluntary. In practice, I'm pretty sure that somehow representatives of the EDPB and the EDPS will be part of this body in order to avoid conflicting different interpretations of the EU regulations. Okay, because there will be two different, this new one and the GDPR. It will be absurd that there will be two bodies with no connection in between them. There will also be a kind of a infrastructure, as I was telling you, a little bit different, that will be a little bit more like kind of functional. Those will be these two cross-border digital infrastructures. One will be for primary uses of health data, My Health EU, and the other one for secondary uses of health data, Health Data EU. And this will more or less help all those member states gain this kind of interoperability of data and so on. And as I was telling you, these health data bodies will be created in all member states just to provide access or not to the data. There's also some important things, is that the main functions of these health data access bodies will be very wide, in order to say they will just make the decisions on the applications, as I was telling before, but they will also do some other things. So they will just process electronic data as such. So this includes the collection, combination, preparation, and disclosure of the data for secondary use. So these bodies will not only collect those data, but they will also be able to prepare those data and disclose some of them for secondary use, okay, and so on. So there will be some very active bodies in so many ways. That's the idea that what they have. They will also cooperate and facilitate cross-border access and so on, but it's more or less what they will be doing. And then let's go, and I don't want to extend too much, but let's go to the last part that has to do with compatibility and the issues that we have. First of all, there are lots of questions regarding compatibility of this new regulation regarding what we have right now. For example, what's going to happen in terms of compatibility with the kind of power that the GDPR was providing the different member states? What's going to happen with that? And this is not so clear. Indeed, Article 33, for example, of this proposal, the new proposal states that while the consent of the natural person is required by national law, health data access bodies shall rely on the obligations laid down in this chapter to provide access to electronic health data. So in principle, it seems that the Commission is willing to bypass the consent requirement, okay, for this kind of new use of data for secondary purposes. And but there are also some other kind of questions that we have, because the GDPR created some national data protection authorities. I guess that you also have that in Taiwan, and all member states have that. And in principle, these data protection authorities are the ones that have the last word about whether data processing is lawful or not. If we are creating these access bodies, what happens if the access body says, yes, we can do this, and we are indeed processing those data, but the data protection authority states the opposite? That will not be so rational in so many ways. So there should be some kind of coordination between them, but it's not so clear at this moment how this is going to happen. Also, as I was mentioning before, what's going to happen with the coordination between the European Health Data Space Board, the EDPB, and the EDPS? We don't know so much. And what is something very interesting is that this new proposal does not even mention the idea of data impact assessments. That is a key concept in the GDPR, because whenever you are doing a kind of processing at the EU level, and you consider that there are some conditions that make this processing, especially, let's say, sensitive, you should have to perform an impact assessment just to make sure that this makes sense and there will be no huge issues in terms of data protection for the data subjects that are involved. So in principle, I guess that data impact assessments should also be made whenever you are processing data. For those who don't realize about this, it's pretty clear at this moment that with this new regulation, in principle, all those data access bodies will be able to process databases that are now, for example, in hospitals or in other places, will be able and will oblige those hospitals to provide those data. And this will be done under the legal basis of legal obligation, and that's all, just like that. In this case, should an impact assessment be necessary? In my opinion, most probably yes, if they are using a lot of different data, and especially if those data will not be anonymized, but it will be something else. Of course, this doesn't mean that a secondary processing will not involve a data impact assessment. Just to make you an example, imagine that you are a researcher that wants to use those data to improve a kind of artificial intelligence tool. You will have to go to one of those bodies that will provide you with the databases, but you will have to tell them that, for example, you will use those data for research. And in this case, you will be using as a legal basis for data processing research as such, or public interest, to be exact. And if you are using those data and they are pseudonymized data, you will have to perform this data impact assessment. So more or less, the main problem is what happens with this data impact assessment and who's going to do that and what will be the parameters for doing something like that. So this will be really necessary. And I guess that there should also be a data impact assessment needed just for the first operation, meaning that the data holder provides those data to the data access body that will provide them to the data user. So it's quite unclear to me how it's going to happen this in practice. And there are also some very polemic statements that are included in this new regulation. Most polemic of all of them, most probably is the part of Article 33.4, which states that electronic health data entirely protected intellectual property and trade secret from private enterprises shall be made available for secondary use. Well, this means in practice somehow that even if you have those databases protected by intellectual property rights, and this is possible at the EU level, you will have to provide them. You cannot avoid that. So somehow this is in conflict with all the protection of the intellectual property rights. In practice, the proposal for the regulation that we are now commenting states that the compensation could be provided, but the amount of this compensation and the rules on that and so on, I mean, I'm pretty sure that should be refined in the future. And also there should be probably some kind of terms of liability for whatever happened if this confidentiality is broken at some time in the process or anything like that. The second and maybe even more polemic statement is the one that refers to information and the need to provide information, because Article 38.2 states that health data access bodies shall not be obliged to provide the specific information under Article 14 of regulation to each natural person concerning the use of their data for projects subject to a data permit, and shall provide general public information on all the data permits issued pursuant to Article 46. This means in practice that if those access bodies receive the data from the data holders, they are not obliged to tell the data subjects that originally provided those data to the data holders that these data are being processed. And this is really against Article 14 of the GDPR and has raised few criticisms by the EDPB and the EDPS. Because in practice, it leaves data subjects with no rights, because if you don't even know that your data are being processed, it's very difficult that you really can exercise those rights. Of course, there could be some kind of general public information on the data permits. And for example, if you got some information that all clinical or a lot of electronic health records that are in the hospital X are being processed, and you are a patient of this hospital, you probably know that your data are there, but there will be no anything like related to information to you as such. Okay. This is weird, and even it's not, in my opinion, it's not really so necessary, because Article 14.5 GDPR already allowed all those responsible for a treatment that they could avoid, kind of personal information depending on the circumstances. But in any way, and there are some issues that remain unclear even with this new regulation. First of all, one thing that has never been solved at the EU level is the type of and nature of this of genetic data, because as we all know, genetic data reveal information not only about the data subject from where those data were obtained, but also about his or her relatives. So we never know if we should consider those data also personal data of the relatives. And this is important because of at least two different points of view. First of all, because it has to do with the rights of the relatives. If you consider that those personal data are data of the relatives, then the relatives could exercise those rights, and we should have more or less to compensate and balance the different uses that all data subjects want to make of those data. And second, it's also very important in terms of data of the deceased people. This, in my opinion, will become a hot potato in the next years, because there are a lot of electronic health records that have to do with dead patients. And it's not so clear what we should do about that, because the GDPR does not really apply to those data, only applies to data of alive, natural people. And so it depends on the member states, but this is dysfunctional at all, because it's impossible to create a whole EU space if member states got different regulation. But in practice, This has not been clarified by the proposal, but somehow this kind of issues, especially that related to diseased people, have somehow been solved because since the legal ground for data processing will just be some kind, of a legal obligation, and moreover, since all types of data will or that a data holder has will need to be processed with no distinction between personal and non-personal data. It's not important. They will all be needed. So all of those data will also be at the disposal of the researchers. And this is all from my part, I think, Professor Chen. I really hope that I've been clear. I know it's very difficult to be clear in this. I mean, it's a very, very difficult issue. And I'm pretty sure that there will be lots of doubts. I guess that maybe Vera Lúcia, that it's an excellent speaker, might help you, dilute this or dissolve this kind of doubts. But of course, I will be at your full disposal afterwards just to try to answer the question. So thank you so much, Professor Chen, for this opportunity again. And the floor is against yours, of course. Thank you. I cannot hear you. No. We just stop sharing my screen. Yeah.
Thanks, Professor Beriain, for his informative and critical analysis of this new draft. I personally have several questions to ask, but maybe after Professor Raposo may comment later. And also, for audience, if you want to have any question, and you can please type down your question and in the chat room. Thanks. And now let's turn to Professor Raposo.
Well, thank you so much. Thank you. It's always difficult to talk after Iñigo because he covers so many issues and with so much detail that I feel a little bit overwhelmed with my very small contribution. But let me do my best. While Professor Iñigo was talking, I took some notes about what he was saying, and also considering my previous thoughts on the European health data space that I would like to share with you. And look, many of the things I will underline have actually been focused by Professor Beriain, because we cannot avoid it. I mean, the main issues, the main problems that European health data space is bringing. And the funny thing is that each time the EU presents a new draft regulation, everyone gets, oh, a new draft regulation, amazing. And yes, it's very exciting, of course, but as exciting as it is, it raises so many issues because all these regulations, of course, deal with very complex domains. They are very technical. Some of them we don't master. There are many unknown factors. They are all very long regulations, and this adds another layer of complexity to our discussion. So what I would like to highlight in my comments are the main concerns I have regarding this European health data space. And as I told you, Professor Beriain already highlighted all of them. So look, one of them, and I think that it is exactly what the first issue raised by Iñigo, is the legal grounds for data processing. As Iñigo explained in the beginning, and many of you are already familiar with, you know that in order to start any data processing in light of the GDPR, you need to find a proper legal ground, Article 6, and if it involves sensitive data, such as health data, Article 9. I will not go into it because Professor, I will call it Iñigo, I'm sorry, I know him for many years, and please feel free to call me Vera. He already mentioned that. Now, here's the point. The recital 37, I went to check it, of the European health data space. It basically says that you still have to comply with the requirements of the GDPR, namely with the need to have a proper legal ground for data processing. So I wonder how it works. In my reading, the thing is that European health data space will make it easier to comply with one of those legal grounds. So you do not have to rely on consent. And also the European Health Data Space also says that you do not have to exclusively rely on the data subject consent, which, as you know, has been a huge obstacle to data sharing and data access, because it's the standard for consent is quite high and demanding in light of the GDPR. So as far as I see, and I would like maybe then Iñigo to comment on this, as far as I see, the contribution of the European Health Data Space is that it will make it easier to fill one of the situations described in Article 6 and 9 of the GDPR. But you don't abdicate of those legal grounds. You still need to comply with it. In theory, it makes sense. As in many things in law, in practical life, I don't know exactly how it will work. So good in theory, in practice, well, we will need to wait and see how it will be applied. The other issue is about data sharing and IP rights. Once again, Iñigo mentioned that. So the European Health Data Space is very keen on IP rights, and it says a couple of times we need to protect IP rights, trade secrets. Yes, in theory makes all sense, because imagine you have all the data. You are a company, like you are, let's say you are a pharmaceutical company, you are an IT company, you have all these health data with you that you are using, and with those health data, in between, you have some trade secrets and some other information that is related to the core of your business. So you need to share those data. You need to share that information. We know, at least in theory, once again, that your IP rights are going to be protected. But how will this work? Now, can you define the information? You say, okay, I'm going to give you this information because these are like pure data, raw data, but I will keep this information because they are related with trade secrets. And who analyzes that? Who says, yes, this is trade secret information, no, this is not, so share this one? I have the feeling, as a lawyer, that most likely some data holders will try to run away from sharing their data just because they don't want to share their trade secrets. So they will try to find a way to circumvent this obligation to share data. Because, you know, every time you have a legal, let's say, a legal obstacle to a business, you have to find a lawyer to find a legal way to run out of that obstacle. So that's what we do, lawyers. So I think in practice, this might happen. Let's see once again what kind of control we will have and what kind of actual protection, legal protection, will be afforded to these trade secrets. Another issue that concerns me is the mechanism for data, the ones that want the data, we call them the data users, the mechanism for them to have access to the data. So as it was explained, there are two main mechanisms, right? And it depends if you let's say, let me put a practical example so you can imagine, you can visualize it. Imagine I am a company developing, actually this is an example I have in my studies. I'm a company developing a new nursing robot, right? And I need health data to train my robot because this is an AI-based technology, which, as you know, needs data. And I want to go to the hospital, which has collected lots of health data for many patients, and request, can I use those data for research? This is one, you know, developing IT and research, digital research is one of the legitimate aims for which you can request data. So I go there, and suppose I'm targeting one single hospital in one single member state. So in that case, I will address my request directly to the hospital. I don't need to pass through these health data access bodies. I can go directly, which is easier, of course. It's very convenient. Now, imagine you are a big hospital, right? And probably if you have lots of health data because you are a big hospital dealing with many patients, chances are you will be attacked by lots of data requests from many companies that want your data. Can you imagine an hospital because there's no health data access body to filter the requests and to take care of the bureaucracies. So it will be the hospital itself, which in this case will be the data holder, to take care of all the data requests, reply, provide the data, all that. Can you imagine the kind of massive bureaucratic mechanism and how many people will be required to address all those questions? And many hospitals, even though of course they have data protection officers, they don't have the knowledge to do that. They don't have the staff. And I don't know how it's in Taiwan, but in Portugal, and I will say also in Spain, our healthcare facilities are now trying to survive because we just had the pandemic, right? There's a kind of economic crisis. They fired many people. So our health situation, it's a little bit complicated. How can our hospitals, both public and private, deal with so many requests for health data? And they have to access each and every request and provide an answer and provide the data. I think it will be overwhelming. Now, the other possibility, the other path to have access to this health data, it's to pass through the health data access bodies. This actually is only required if you are addressing several entities in several member states. So once again, I'm a company developing an AI robot. I need health data, and I'm going to target different hospitals in different member states, asking for their data for this secondary use. In that case, I cannot address them directly. I need to address the health data access body. And here, my friends, it gets really complicated because look, so I, the one that wants the data, I'm the company that wants the data, I go to the health data access body and I formulate a very detailed request explaining why do I need the data, for which purpose, how am I going to use the data, what safeguards like data privacy safeguards, privacy by design, privacy by default, am I going to use, all that. Then the health data access body will make an assessment of my request. It has 2 months, but that deadline can be extended. Most likely it will be extended. We know how bureaucracies work, right? So they will assess my request. If they say, yes, okay, you can use the data, they issue what Iñigo already mentioned, the data access permit. But it's not that I can go to the hospitals to ask for the data. No, that will be too easy, right? And we on the EU, we don't like easy. We like to put it difficult. So the health data access body will go with the data permit to each and every hospital. And then the hospital will look at the permit and has 2 months. Each one has 2 months to release the data, and the deadline can be extended. Most likely it will. Now, but they will not release the data to me. Again, too easy. They will release the data to the health data access body. Are you lost? Because I'm totally lost. So we go, it's not a direct way from me, company, to the hospital. I always have to pass through the health data access body. All kinds of assessments, various deadlines. So bottom line, it can take years before I have the data in my hands, which basically jeopardize the entire purpose of the health data, of the health data access body. Of course, it will depend on how well equipped the health data access bodies will be, and that will change because we have already the experience of the data protection authorities in different member states. So you have member states where the data protection authorities are very expedite and very efficient, let's say Germany, and we have the ones in which the data protection authorities are very slow, let's say Portugal. And I'm afraid this will also happen with the health data access bodies. So bottom line, it's a very bureaucratic procedure. It's very lengthy. And I don't know how efficient it will be. Another issue I have is with the harmonization between electronic health records. So as Iñigo mentioned, another big goal of the European health data space is that we want to make the different European health records, which are digital health records. I mean, I'm talking about digital software, if the word exists, across the member states, compatible between themselves. So the health data can freely circulate among the entire EU, right? So the idea is that the software in which these medical health records are based on has to be compatible. And for that to happen, there must be a compatibility assessment. So they need all softwares for medical health records need to comply with certain requirements. And if they comply with the requirements, they will get the CE marking of conformity, right? Saying this is good to go. These they can work together. The data can flow between the different softwares. And I think this is a very good idea. Of course, needless to say, the problem of software compatibility has been a huge problem in the EU, even in light of the directive on cross-border healthcare, as actually Iñigo also highlighted. But there's always a but here, right? But here's the problem. Imagine you are a company developing software for electronic health records, right? You have your company, all good. Now, how many certificates you need for your software? I'm going to tell you. So you need the certificate according to the European Health Data Space, showing that the software can work. Is in conformity with all the other softwares, right? Basically, that it can work together. And you also need another marking of conformity to indicate that it's compatible with the medical device regulation, because health software is a medical device. So the medical device regulation imposes another assessment and another marking of conformity, saying that it's good to go. And then you need another CE marking of conformity, I'm counting 3, in light of the proposal for artificial intelligence, the artificial intelligence regulation. I actually gave a talk here about that. So you need to three different CE markings of conformity, 3 different assessments. And in the bottom of all that, you still need to make sure that your software is complying with the requirements of privacy by design and privacy by default as established by the GDPR. How bureaucratic, how costly it is, I don't know. Let me put it like that. I don't want to be the one creating a software company for medical health records, because I think it will be just crazy. So bottom line, and I'm finishing to give you also some space to talk. We have been told that it will be like the best of the worlds. European Health Data Space will solve all the issues regarding health data. It will be like the health data heaven here in the EU, birds and butterflies flying. I very much doubt for the reasons I just mentioned, but let's see if you can help us to find some solutions for our problems. Thank you so much.
Okay, thanks, Vera, thanks, Raposo. And I have several questions, but before I ask, is any people want to ask questions? Okay, well, in Taiwan's culture, maybe after someone asks the first question and other question will come in. So I will ask question first. Okay. I have several questions. First of all, Professor Beriain, you mentioned that the Europe want to have space. Data space actually is for many types of data, not just the health. So for this regulation, and why what's the difference with health data with other type? Is there any other type of regulation for maybe finance data space are proposing? Why health data space become the first one? And particularly, you mentioned that Article 9.4 GDPR gives member state a lot of power. So why the EU choose that this area that when states, the member state has such a power to decide as their first? Yeah, this is my
Thank you. Yeah, it's a very good question. Well, you should consider what will be the great advantages on the main issues that have to do with health as such. First, it is true that the EU wants to create these 9 spaces, all of those different spaces somehow. Well, I think that they have chosen health data because it's much more easier easy to convince all EU citizens that it's good to share your data because they will be used for purposes that will have to do with a general improvement of their health, that to convince them that they should be letting you share the data because that will be good for the finance, for example. So in terms of marketing, it's much easier to sell the idea of data spaces if you stop at a kind of data space that will be related to health. On the other hand, it is true that health data are much protected than some other types of data. But, and there is something else in this that is very tricky, and I guess that Vera Lúcia will also have a word on that. One thing is what you define as health data and what you do not define as such. And this is very difficult to do because in principle, there are some data that do not seem to be health data, but could perfectly be used for purposes related to your health. And for example, in our countries, data such as, I don't know, your zip code, or data such as, I don't know, how many times you use your credit card every month, in theory have nothing to do with health data, but in practice will have a lot of things to do with the price that your insurance company will make you pay if you are contracting this kind of, health-related insurance. So first of all is how you make this distinction of what it is and what it is not. And I guess that as Vera was mentioning, companies will or might use this kind of approach in order to avoid sharing too many data. They could say, no, these are not health data and I will not share them, okay, for example. But the opposite could also be true. I mean, that someone, a data user, would like to have access to so many data, assessing that this could be used for health purposes. So there's another difficulty in that, which is distinguishing what is and what is not health data, indeed.
Okay, thanks. The one participant asked a question. Are there any limitations for a pharmaceutical company to use those data for developing new drugs?
No. The answer is very clear. Not at all. The pharma company, okay, they should ask for the data, and they should, one of the things that they should have is a legal basis that allows them for data processing, meaning if they want to use those data for research, for example, they want to develop a new drug, they could do that if they are really making a research that really works well with the definition of research usually made in terms of what it is, research in scientific terms. But the GDPR in general allows the use of data for this kind of research, and it's enough if the company states that this data will be used for research purposes that have to do with public interest. So they will have a legitimate basis that will be public interest, and they could use those data. So it is. Main problem that happens with that is that the idea of the compensation, because at some point it seems a little bit unfair that those companies might gain access to the data for free or for just a reduced amount of money, and they could have huge benefits from the research. So, but there's another issue. I mean, that will have to do with whether some compensation should be introduced in the system or what. But in practical, yes, the company could use those data, yes, for research purposes, for developing new drugs, for example.
Yes, but what if the new drug is for emergent public health issue, for like a fighting pandemic, or so they want to develop a vaccine or drug, so at urgent time, so would it be permissible because it's combined with the public health issue?
Yeah. Indeed, we have different type of a legal basis. One has to do with they will all have to do with the public interest most probably, and you could justify the development of new drugs, and you could justify the use of these new drugs in terms of public interest in using them, especially in terms of pandemics and so on. Instead, in case of the circumstances and how to avoid the debate of using these categories of data, you have two different circumstances. One is the scientific research, and the other one will be kind of a public health issues and so on. Okay.
Okay, thank you. And in one of your slides, you mentioned that the change of new strategy, because 2020 there's a European strategy for data, which was promulgated after 2 years of effective GDPR. So this is a quite of a change of strategy. So as you just mentioned that maybe the drafted regulation maybe have some conflict with Article 9.4 GDPR. But do you think this is just because this article? So member state will have an opportunity to decide what range they want to encourage this kind of sharing. And the thing is that although health data is a sensitive data, but I found that the health data often be the type of data that we want to share have a not more. We have a larger demand to share the data because it has this kind of share we can create results maybe good for all people, and so but for this change, you think is relating to the required consent. I mean, what I think that it seems that under GDPR, consent seems quite a fundamental mechanism to protect people's rights, and so sometimes those data will consider a part of personality. So even those data is not revealed, it's pseudonymized. It cannot, but it cannot be identified. But it's still because it's a part of the personality, so it's required consent. But what we are facing is that there are some certain technology that we can use the software to process the data, but the researcher will never get access to individual data. So the researcher can only see the statistical result. So, but under the traditional concept, because it's still use the data, so even it's not identified, but it's still used, so it's require consent. But it seems that under the new strategy, it's changed. So I wonder, how do you think about it? Yeah.
Yeah, in my opinion, really, what has happened and I think it's I agree with this term. I think that first of all, one must consider that in the old directive, consent was the most important legal basis for data processing. Okay, I mean in the directive that was there before the GDPR. So there was a kind of a culture of research that was based on consent, and consent was impressively important for a very long time, and no research could be done without consent by the data subject. I think that this is not a good idea, and I will try to explain you why. To my experience, lots of data subjects, especially when they are patients, somehow feel vulnerable, and if you just ask them for consent, they usually say yes to everything and sign whatever you put in there. In practice, this means that they are not protected, because you could even make them sign, that they just let you use the personal data with even no pseudonymization. So they could consent for a lot of things. And for example, the EU is now really somehow considering that consent provided, for example, in the framework of clinical trials should not work as a nice database for data processing. Of course, consent is needed for participating in the clinical trials, but it's not a good legal basis for data processing, because patients participating in clinical trials are very vulnerable. So their consent for data processing might not be a nice legal basis, because it could be not so free in so many ways. So that's more or less the point that they have. I think that they are right at some point, that the most important thing in order to protect data subjects, it's not really if they provide consent or not, but the safeguards. I mean, the type of measures that you introduce to make sure that those data will not be used against their interest. So in that sense, I think it's a very good idea. I mean, when I saw this before, I mean, when I was just looking at this new proposal, I think that it introduced really valuable safeguards in the sense that those data users will only gain access to pseudonymized or anonymized data, and in a kind of very quite safe environment. So it's very difficult for them to re-identify data subjects, and it will also be very difficult for them to use those data for some finalities that are not really the finalities allowed by the regulation. So I think that is somehow a quite a strong point that makes it a little bit easier, you know, to go ahead without using consent, but protecting really the data subject, in this case, the patients of the users of a healthcare system. So it's not so bad, in my opinion. It works well. It was much more, you know, I mean, what some of the member states were doing, that was requesting, again, some informed consent for research. It made it impossible in practice in so many ways, and it was a kind of a nightmare. So I think that this worked well in that way. Main problem, and I will just make a follow-up on a Vera Lucia's argument. Main problem that I feel here is that the EU is trying to solve through regulation some kind of issues that should be solved through the money. Main problem is that you can have very nice databases and flexible access to those databases and so on, but you need to spend a lot of money to do that. Because, as Vera Lucia was saying to you, in my opinion, it will be a good idea to have this access body working there and serving as a kind of, you know, of key tool. But if those access bodies would be really efficient, if they will have an splendid structure, they will have excellent operators there, being able to anonymize the data, structure the databases, process all the requests in a very short time, and so on. If they are very professional, they work so well, that will be fantastic. Main problem is that I don't think that this is going to happen. And I share, you know, Vera Lucia's suspicion that this probably will be very different in the EU countries. What's going to happen if this happens on the other way around? It will happen that most probably research will be made in all those member states that have invested the money in having those excellent access bodies and providing excellent access to very nice databases. That's what might happen in the future. You know, that there will be even some competition between the states, but the competitions will have to do with the degree in which those access bodies are performing the work. If they are excellent and they provide excellent databases, that will be a great advantage for some countries in doing so. But for some other countries, it will be very difficult to reach that point. That's why I really think that might happen.
Okay, thank you. Would Professor Robson want to have some response to the question in terms of consent? Yeah.
No, not really. I think, look, I think Iñigo was very clear and also sharing some concerns, and his answers, not at all. I will pass the floor to our guests.
Okay. As the dean of a law school, of course, I want the government have more laws, and sometimes contradict law would maybe bring more business to my to the graduates of the law school. Yeah, but do you think that maybe GDPR need to will consider to make some amendment that's such like Article 9.4, so it will be more consistent under a new approach, since they are all met by the same commission?
Yep, but maybe one of the things that we should also keep in mind is that, as I was commenting before, it's not only the GDPR. Now the different DGs are producing the Artificial Intelligence Act, the Data Governance Act, the Data Act, the Digital Single Markets Act, and the Digital Services Act, if I'm not wrong, just to begin with. So we have at least 5 regulations related to data that are now in the process of approval. So this will be a kind of a nightmare in order to conciliate them all. But you always have to also consider that the EU is a complex.
Iñigo, I remember another one. What about the new e-privacy regulation to substitute the directive, which will be more stringent?
Yeah, you're right.
This
is very important. This is very important due to a simple thing. We were talking about circumventing concept. Yes, it's true. But in the EU regulation, when something has to do with a digital data that comes from apps or medical devices or so on, then the e-privacy directive rules, and the future e-privacy regulation will rule. And the e-privacy regulation requires consent as the legal basis for data processing. So one of the things that they will have to solve is how to conciliate both of them. And of course, they have to ensure conciliation with all the rest. So it's not only that probably they will have to find a way to conciliate the GDPR with this new regulation, is that they have to conciliate a lot of them. And one of the main problems, I think, is that, sometimes the different DGs produce some regulations, but they are not so well interconnected in some ways. And then it's our job, Vera's and mine and so on, to try to find out a way to conciliate them from a legal point of view. So somehow the headaches come to us because we have to study lots of different legal tools, and we need to find some way of solving the issues. Of course, most of these regulations now include a kind of preliminary analysis of compatibility and so on. And in theory, everything works so well, but in practice, it does not happen so often. And we have a lot of conflicts in there. In the case, once you consider, and I think that it's important, that the main aim of the Commission will be to open the space and try to make all things needed in order to allow this data flow, all interpretations will be in the sense of trying to make this happen, or at least that's what the Commission will be looking forward to. Let's see in practice what happens, okay? But I guess that they will try to do their best. And if those bodies will have to make some kind of authorized interpretations of the regulations, most probably the conciliation will be in the way of, let's use the interpretation that works better with these proposals of ensuring a nice data flow. That's the idea that will be in behind. But let's see how it works in practice.
Okay, thanks. I have 2 more questions. One is in terms of in this regulation, there's a new committee was created as a safeguard to this. And also we found that for under GDPR, there are certain board or the data protection authority, but I found that in some member states, the data protection authority is not a committee. It's maybe head by a single person. There is a person who lead the department. So such as ICO in UK. So how do you think, compare with actually before this webinar, I just have a debate with some law scholar and in another city. So I just come from another city. So that's why I get online so late. The thing is that how do you think about comparing with the 2 forms? One is as a committee. The other one is lead by a single person who have a broad power and authority and bear the solo responsibility. So how to compare these 2 types of form as a data protection authority?
Well, it's not only that even some countries do not have a national authority as such. In Germany, indeed, it's not a federal competence, but it's kind of a Länder competence. So there are a lot of different data protection authorities in the Länders. Also happens, for example, in Spain, we get a national, but we have also some regionals with some competences. So it's quite a nightmare in order to know how to conciliate that. And even more, as Vera was commenting before, the number of members, the activity, and everything related to the data protection agencies depends on the member states, who are the ones deciding of how to organize this. And it will happen the same with these access bodies and also with the digital authority that will be created supervising the whole system. It will depend on the member states. So my perception is that there will be also huge differences in these access bodies and health authorities and whatever in all the member states. I don't know, Vera, if you are more optimistic and you consider that it will be the other way, but I think that it will be very much the same that with data protection agencies.
Exactly. I think they will follow the same model. And as you know, Iñigo, you have states in which it works very well and states where don't. And the other thing, not only the composition, even the kind of decisions. For instance, I remember once I went to a session, like a conference. This is before I moved to Asia. And there was someone from Spain talking about companies that deal with digital health. And there was someone from Spain, and he was talking about the wonderful things that they were doing, and of course, approved by the Spanish Data Protection Authority. And I know that those things will never be approved in Portugal. And even though our law is pretty much the same, right? By that time, we still had the DPA, the Data Protection Directive. So, but exactly the same. I mean, our margin of freedom of national member states was not that big, so that your data protection authority will decide in such a different way from ours. I mean, some are more flexible, some others are very stringent, as mine. So probably the same will also happen with these new bodies.
Mm-hmm. Yep.
Okay, thank you. One final question. This is in terms of genetic data, I have a long question that is it possible to anonymize genetic data? Because it seems that genetic data would be show the essential of a human. It's not like any other health records. Other health records maybe can be created by different patients, but your genetic data can only, I mean, it can be used to identify yourself. So it is possible to totally de-identify genetic data. This is a question I'm curious about. And I asked some doctors, they say that when they do research, they only get a small piece of human genetic data. So those data is enough to reveal the whole identity of the person. But once you want to gather so many, you want to have a data flow with such large scale, and researcher can have a huge amount of data. Is it possible that a researcher can put that together and they can get a full picture of human identity? So this is a question is a long question I have wondered. Yeah.
Yeah, first, from a technical point of view, well, it's very difficult to anonymize genetic data. That's true. The only thing that the regulation foresees is that it's totally forbidden for data users to try to do that. Okay.
Okay.
They cannot even. So in principle, if they do that, they could be sanctioned. I'm talking by memory, but I think that some of the sanctions that it includes is that those data users would never be allowed again to gain access to data and so on. So there are some kind of sanctions. I don't know what's gonna. I guess that even some kind of illegal processings will receive a fine by the national data protection authorities and so on. But those are all, of course, reactive measures. That are just directed to say, well, if you do that, we will really punish you. But from a technical point of view, okay, in theory, it should be the access body, if you are using the access body, that should guarantee that those data are really anonymized data, if those are really considered as such. not so sure on the real degree of anonymization that you could create from genetic data. I don't know what Vera considers about that, but in my opinion, it's true that it's very difficult. Also, biometric data are very difficult to totally anonymize. So I don't know what you consider, Vera, but it's hard to do in practice.
Well, I think anonymization in general is a decoy. I think people trust in anonymization because they believe, well, if I deal with anonymized data, I'm okay. The GDPR does not rule here,
Right.
but it's not at all a liability shield. Back in 2013, there was an article published in Nature where they demonstrated by means of an actual experiment that they could re-identify most of the individuals from a database of allegedly anonymized genetic data. And so for genetic data, and as you just mentioned, biometric data, I think in particular, it does not work at all. And even in general, for other data, there are many events that show that especially by now using AI, it's very easy to do some kind of reverse technology. And you don't need to be like the most expert IT in the world. Remember, I don't know when, 2018, 2019, a group of journalists from, I don't know, Washington Post, whatever, I don't know, from the US, they managed to have access to the tax data of President Trump, exactly, which were allegedly anonymized by that issue, right? De-anonymizing data. So it's very easy. It's not a data shield, and especially does not protect anything regarding genetic. I totally agree with you.
Yeah, I know time's up, but may I have one more question? Actually, I recently participated in an AI project, and we are asked to prove that when data controller analyze the data, the annihilation did not against data subject's will. But my understanding is that when data controller want to anonymize the data, it does not require consent, right? Does it require consent under GDPR that when data controller want to anonymize the data, does it require consent from data subject? I think it is some kind of an impossible. Yeah.
Not exactly consent, but anonymizing data is a kind of processing. So you need a legal basis for data processing. It might be some other legal basis. Could be, for example, public interest, could be legitimate interest. If you're a private company, you could say, well, I'm anonymizing all that because I got a legitimate interest to do this. For example, that I want to prepare some kind of new artificial intelligence for my patients. And this is a legitimate interest that allows me for anonymizing all that, okay? But you need a legal basis to do so. The processing data to make them become anonymized data is as such processing, and you need a legal basis for data processing. You need to do that. And somehow it's also true that the GDPR in general puts some pressure on everyone who is willing to use personal data, because the first thing that you need to consider is whether you really need to use personal data. Because if this is not the case, the first thing that you should do is anonymize those data. So that's more or less what the minimization principle state. If you don't need to use personal data, don't use them. If you get personal data, but you really can anonymize them for your research, then anonymize them. That's more or less what the minimization principle state. But of course, you will need a legal basis to do so. Okay, so it's not outside the scope of the GDPR. Once they are anonymized, at least in theory anonymized, then they are out of the sphere of the GDPR. And by the way, I dare say one thing. One of the nice things that at least this regulation does is that it creates somehow a legal framework, a little bit clearer legal framework for anonymized data. Because one of the real issues that we have at the EU level is that once those data are supposed to be anonymous or anonymized, then it's not so clear what kind of ruling applies, because it's somehow a great black hole in there. You know, you just say they're anonymized, and from that moment on, what kind of regulation.
It's the Wild West, Iñigo. It's the Wild West. You can do whatever.
Nothing applies. From that moment on, it's like, okay, they are anonymized, so no longer personal data. So prepare the party because everything is ready, and that's all. You know, that's one of the issues that we have.
Okay, yeah. Thank you very much. Well, although actually we might have more questions to ask, but I hope that we can end this webinar at the promised time. I would like to thank our speaker and the commentator for their informative presentation, and also those kindly ask our question in details. And I hope that I sincerely hope that we will see them in the future. And also we hope we can learn from the knowledge and wisdom. Yeah. And I want to thank all of your participation tonight. And we hope to I mean, this is a quite essential issue for Taiwan's digital strategy. Yeah, so I sincerely hope thanks for your participation. And in the future, in the next few months, for example, like September 25, I'm planning to organize a conference in person about commercial use of health data. And on December 3rd, we will have a national technology conference. We have a one-day event for digital health law. So anyone who are interested are welcome to participate in the future. Thank you very much, and thanks again for our speaker and commentator. And thank you all. Good night.